What's his number? Where? Mad Hattie?
Yeah. Close.
Is that his name? Wait. Hold on. Let's make sure we got the right person. Davi Elmina. Okay. Counsel, you want to come on up here so she can hear what we're talking. Make sure she hears us. Marty, this is Judge Parrish of the Lake Circuit Court.
Hi, how are you?
How are you? We're on the record in the matter of the State of Indiana versus Elizabeth Campbell, 45 CO1 1211 MI 00166. Will both counsel identify themselves for the record?
Sure, it's Robert Varga for Elizabeth Campbell.
And Marty Menon on behalf of the Bureau of Motor Vehicles.
Okay, and we're here on your motion to set aside judgment?
Yes, Your Honor.
All right, are we ready to proceed?
Yes.
Okay.
Your Honor, on May 8, 2013, petitioner was granted a hardship license pursuant to Indiana Code 92415. The Bureau of Motor Vehicles would object to this hardship license. Ms. Campbell was suspended for a chemical test refusal, and she was suspended under Indiana Code 936-9E, and therefore she's ineligible for a hardship license. I would point to 924-15-9, which reads that except as provided in section 16.5 of this chapter, an individual may not be granted restricted driving privileges if the individual's driving privileges are suspended under 935 through 939 or 930-13-3. And since Ms. Campbell was suspended under Indiana Code 936-9, for the refusal to submit to a chemical test, she would be ineligible for a hardship license under this chapter.
Yes, Judge. There's one inaccuracy. The May date that counsel gives was actually on a request for a petition for an amended order. The original hearing was undertook in November of 2012. When we had a file stamped order resulting from that in January of 2013. So it's a much longer period of time that Ms. Campbell was actually operating with the court order for the probationary driving privileges. What happened in this case, just for procedure on the pending OWI, before I was able to get a copy of the information and the probable cause affidavit, we were aware of Ms. Campbell. She had been arrested and posted bond. I prepared the petition immediately, and even in the petition, we stated that the cause number was yet to be determined. So at this point, through no fault of Ms. Campbell, were we even aware that there was going to be, I wasn't aware that there was going to be an issue of refusal. Ms. Campbell's not determined.
When you first filed it.
Correct. What has since happened then, it was granted in the now the OWI case, which is still pending, remains pending. We filed for an amended order because she changed jobs, and according to the statute under the hardship provisions, the route to and from work is mandatory as contained in the order. And it is when we filed the amended order, so the BMV never objected to the original the original issuance, which I believe that they should have done and have since waived it. Number two, that since they have waited this many months, when it was their duty to otherwise respond or object, this is not going to work on undue hardship because the address has been changed and now her distance is significantly greater travel time from where she lives to where she works. And thirdly, she was never received adequate notice pursuant to 93069D sub 1 and sub 2. Not only does there have to be an allegation in the probable cause affidavit that there was a refusal. That allegation has to be supported by a finding that there was probable cause, but more beyond that, the BMV must notify. They are required to notify a suspended person's driving privileges. This shall immediately do the following. D sub 1 is mailed the notice to the person's last known address. They had her address. It was the address of her state-issued driver's license. 5 days after the date of notice, or on the date the court enters an order recommending suspension. The BMV has neither alleged and shown in their motion any order or recommendation from the court recommending suspension, nor have they proven up notice. I have Ms. Campbell here today is willing to give testimony if the court would like to swear her in that she never received notice pursuant to statute. Without that, that does not destroy her ability. It does not destroy her ability to continue under the probationary privileges due to the BMV's failure to adequately notify her. So those were the.
So your argument is she needs to get a notice of the administrative suspension.
She must.
And never got a notice of the administrative suspension.
That's number one. Number two, it's kind of like a laches defense. That they can't use this May date for an amended order. You have to go back to November when the hearing was originally done, and they were notified by a file stamp order of January 2nd, I believe it was 2013. And they wait until a point in time where Ms. Campbell, doing what she's supposed to do, notifies the court due to a change in work circumstance and a change in route. It was only after a request for an amended order, not the granting of the initial probationary privileges, just a modification of the route, that they raised this in. So for those reasons as well, they waited too long. I don't think it's good cause then under 60B.
So when was she notified of the suspension?
She was essentially I knew a suspension just in any OW. We knew it was an OWI charge. That's all I knew.
So you're automatically suspended?
You're automatically suspended. The question was going to be under which section. And I don't dispute that ultimately, based on the probable cause affidavit, there's the allegation that she refused. Now, I'm preparing my petition.
So you needed those in what section she was?
And this is the BMV's requirement. Now, this was in effect as up till January 1st of this year, so this was the relevant statute that Ms. Campbell would be governed under, which is 936.9, and under sections D1 and D2, it is mandatory. They must do this. If they don't do it, that's in violation of the statute. The suspension can't attach, Judge.
Yes, Your Honor. It seems that counsel is not only challenging our ability to seek relief from judgment on the hardship license, but also is questioning the validity of the suspension in the first place because of the alleged lack of notice. And I'm not sure that's relevant to our motion, which is relief from judgment on the order to grant the hardship license, because Ms. Campbell is not eligible for that. But in any case, if you will look at Exhibit A of my motion, I've attached Ms. Campbell's official driving record as of July 1st of this year, and you will see that the chemical test refusal suspension is on there, and it has a mail date of December 4th, 2012, and it was mailed to address ID7. And if you turn to page 2, address ID7 is listed there as 1025 East Glen Park Avenue, Apartment A, Griffith, Indiana. That is the address that the BNC has on record for Ms. Campbell, and that is where the notice of the refusal suspension was sent on December 4th, 2012. But that's the issue of notice, and I don't think that's relevant to whether or not Ms. Campbell was eligible for a hardship license. I don't see that the BNC has an order from, I believe, council dated January of this year. The order that the PMD received is the second amended order dated May 8, 2013. And that is the order that the PMD is arguing is contrary to law because it grants a purchase license when the petitioner is not eligible to receive one. And I did not hear council making an argument as to that point that Ms. Campbell was suspended chemical test refusal, and the statute really states that an individual suspended for chemical test refusal is not eligible for a purchase license, and that's simply the matter of law. It's not allowed for any discretion or in any way allowing Ms. Campbell to be eligible for the service license.
Okay. When is her DUI going to be resolved?
Well, what's happening now is I'm filing a petition for judicial review of probable cause on the refusal and a motion to suppress. Our next hearing on that is set for September 26th. If anything, Judge, just so the court is aware, I'm sure you have it in your file. I have my file stamped copy of the January 2nd, 2013. That's the initial date of the order from a hearing that occurred on November 8th. Again, I'm not disputing the fact that the BMD can't object or people would not otherwise ordinarily be eligible. But under these circumstances, that doesn't forgive or excuse the BMD for failing to act within the appropriate time period and raise the objection. Under a 60B or under a 59A, and either one of those, which I guess you could consider, whether it be, I know they filed under 60B, I would think that this would even be more of a 59A matter, but even under a 60B.
Where's the good cause? This isn't an excusable neglect case. This is where they had the original order. They waited, they did nothing, and now when there's going to be an amended order, I would suggest that the court, for those reasons, and in the interest of justice, it's not a ruling that would be, we're not suggesting that the statute is a discretionary statute, but unless they make the appropriate legal objection claim at the proper time, it is judicial discretion on whether or not to grant relief under 60B. And I think it would work an incredible undue hardship after having a woman filed in November. This is no fault of Ms. Campbell. She's not an attorney. We filed it before we got the probable cause affidavit in order to preserve her right to a job and get this, and then wait more than half of a year before they decide to exercise this objection, which they should have done on within days of January 2nd of this year. That's going to be our position.
Okay.
I think it would be an undue hardship as well.
Anything else from the state?
Nothing further, Your Honor.
All right, I'm going to take this matter under advisement, review these materials that have been submitted by both councils, and I'll have a decision within a reasonable.
My copy of this, the pre.
Yes, if you would give me the statutes that you referred to.
Yeah.
All right, anything else?
Nothing further from Petitioner Judge.